Ever wonder what happens if you just, ask your homeowners association to see the books? Well, for one resident in Arizona, that very simple request, it turned into a massive year-long legal battle. And let me tell you, this is a story all about fighting for transparency, and it has a twist at the end that, wow, nobody saw coming.
So it all starts right here. This one sentence from Nancy Babington's official petition, it just perfectly sums up the whole conflict. I mean, she did everything by the book, right? She formally requested the records, and a month goes by, and she gets absolutely nothing. And that, right there, is what kicked off this whole legal fight.
Okay, so let's set the stage a little bit. On one side, you've got our main character, Nancy Babington. She's a resident at the Scottsdale II Townhouses out in Arizona. And on the other side, her HOA, which, by the way, is managed by a big company called Associate Arizona. And really, all Nancy wanted to do was see where the money was going. And this wasn't some vague fishing expedition. No way. On May 1st, 2020, she gave them a very, very specific list. She's asking for things like bank statements, signed contracts, minutes from their meetings. I mean, these are pretty standard documents, right? The kind of stuff any homeowner would want to see to understand, hey, where's my money being spent?
And this is where the law really comes into play. See, Arizona has this super clear rule on the books. People call it the 10-day rule. It basically says an HOA has just 10 business days, 10, to hand over any requested records. And let's be clear, this isn't a suggestion. It's a hard legal deadline, and is pretty much the entire foundation for this case.
So let's just walk through this. Nancy sends her first request on April 29th. The official 10-day clock starts ticking on May 1st. By May 14th, crickets, total silence, so she sends a follow-up email. Fast forward to May 25th. That's nearly a whole month after her first email, and she's still got nothing. At that point, she's had enough, and that's when she decides, okay, time to escalate this, and files a formal petition. All right, so this petition, it leads to the very first hearing on August 28th. This is where the HOA finally has to explain themselves, right? They have to defend why they've done nothing, and their defense, well, it was basically a story about a very messy breakup with their old management company. Their whole argument was pretty simple, really. They claimed, hey, we can't give Nancy the records because we just don't have them. They testified that their previous management company, a group called CMC, had just up and quit on them, terminated the contract super abruptly, and was holding all these key financial documents hostage. So they argued it was literally impossible for them to comply. And this quote right here from the judge's first decision, it just nails their legal position. They weren't saying we refuse to give them to you. They were saying we can't. It's an impossibility defense. The records just weren't in their possession. And you got to admit, on the surface, that sounds like a pretty good excuse, right? And you know what? At first, it actually worked. The judge totally sided with the HOA. The ruling basically said, look, Nancy hasn't proven her case because you can't force an association to produce records it doesn't have. So for the HOA, this was a huge win, a clear victory. And for Nancy, well, it looked like it was the end of the line. But the story was not over, not by a long shot. Because after that first hearing, when the HOA finally released some of the documents, a really surprising twist came to light, one that was about to change absolutely everything. So the HOA had won. Their defense seemed totally airtight. But was that really the whole story? Well, after the hearing, the HOA finally sends Nancy some documents. And buried deep inside that pile of paperwork was one tiny detail that was about to flip this entire case on its head. And here it is, folks, the bombshell. The HOA had claimed, under oath, that they didn't have the records. But the documents Nancy was now holding in her hands proved that just wasn't true. She found proof of bank statements being sent to their management company. She found contracts signed by the board. And all of this was dated before she ever even made her request. The evidence, as the judge would later put it, was directly contradictory to what they had testified in court. So, armed with this brand new, undeniable proof, Nancy does exactly what you'd hope she'd do. She successfully files for a rehearing. And this sets the stage for a super dramatic round 2, where the HOA's original story starts to completely fall apart. Okay, so in round 2, the excuses start flying, but they just don't stick. For the bank statements, their new excuse was, oh, well, those were sent to our main office in Richardson, Texas. The judge's response? Yeah, that's still your company. They were in your possession. And for the signed contracts? Oh, the board members hadn't given them to us yet. The judge's finding? Nope. The contracts existed, and you should have provided them. Their story was just unraveling fast.
So in this second hearing, the judge does a complete 180 and reverses the original decision. The ruling, the HOA absolutely violated the 10-day rule. Now, their lawyer tried to argue that the whole case was moot, basically saying, hey, she has the documents now, so what's the big deal? But the judge was not having it. A violation is a violation, and there are going to be consequences.
So what's the price for non-compliance? Well, first, the judge ordered the HOA to pay Nancy back her $500 filing fee. Her fight was completely justified. But it didn't stop there. Oh no, the judge also slapped the HOA with a $2,500 civil penalty. The message here could not have been clearer. If you ignore a homeowner's legal rights, it is going to cost you. So what are the big takeaways from all this? Well, for one, it proves that homeowners have real, legally protected rights. It also expanded the definition of possession, making it clear that if your HOA's management company has a document anywhere, even in an office in another state, your HOA is responsible for it. It shows that dragging your feet and ignoring requests can have some serious financial penalties. And maybe most importantly, it proves that persistence is absolutely crucial. Thanks to Nancy Babington, we have a great reminder that even if you lose the first round, it is not always the end of the story. And that really brings us to the final question, doesn't it? This whole huge case started with just one resident asking some pretty simple questions. It really makes you think, if you went and asked your association for its records, what would you find? Just how transparent is your HOA?